Welcome to everybody. I was just waiting to let people come into the room. This is the Migration and Privacy Roundtable, how privacy and data protection law can help defend migrants' rights. And my name is Louise Hooper from Garden Court Chambers. Amanda Weston, who was due to chair tonight's event, is unfortunately unwell, so I'm stepping into her rather large shoes to fill. We'll introduce the panel to you. In terms of migration and privacy, it's becoming a bigger issue, both domestically and internationally. And over the course of tonight's seminar, we're going to look at some of the work that Privacy International has done and look at some of the avenues of challenge that have been brought so far in terms of protecting migrants' rights using data protection law, privacy laws, and other angles. And on that note, I'm going to hand over to Lucy. Thanks, Lucy.
Thank you, Louise. Let me just share my screen. Right, can everyone see that all right? Perfect. So good afternoon, everyone. My name's Lucy Audibert. I'm a legal officer at Privacy International. Thank you so much for joining us for this roundtable that we have co-organized with Garden Court Chambers, to whom we're very grateful for hosting and for helping us gather such an impressive list of speakers. For those who don't know Privacy International, we're a London-based NGO that researches, advocates, and litigates globally against government and corporate abuses of data and technology. We're usually known in the UK for our litigation against intelligence agencies or for our complaints against the ad tech industry. But we're now funded to work with the migration sector and to use our expertise for the benefit of organizations and rights defenders in the migration field. So please do get in touch if you're interested in hearing more about our work. So the purpose of this roundtable really is to show how privacy, data protection, and migration are areas of law we should be considering together. We've seen in recent years in our work a considerable increase in the surveillance capabilities and digital technologies deployed to control migration and administer the border, with a corresponding reduction in rights and protections afforded to migrant communities against this kind of acute surveillance. So I'll mention some examples of our recent work in this field. They're listed here on the slide, and I'll be sharing some links in the chat afterwards. So earlier this year, we released a guide on the UK migration surveillance regime. It outlines the databases and other surveillance tools used by the UK migration and border authorities to track and monitor migrants, while showing the companies that profit from that by selling their tools and services. This year also, we campaigned against the Aspen Card with other migration groups. For those who don't know it, the Aspen Card is a debit payment card given by the Home Office to asylum seekers on which they load their subsistence allowance, and that we've seen the Home Office use to monitor how the allowance is spent and take punitive measures if spending patterns don't align with what they would expect an asylum seeker to spend. We obtained some unsatisfactory answers from the Home Office about the extent of monitoring and the various data protection rights afforded to asylum seekers. And we're pushing for further answers and changes to the system. Another aspect of our work revolves around the financial drivers of surveillance. And so last year, we revealed the extensive use of EU development aid and cooperation funding to train and equip border and migration authorities abroad, such as in certain African countries or in the Balkans. We wrote to the European Commission to ask that it enacts urgent reforms to EU cooperation and aid programs, and that it keeps pushing for transparency and accountability of spending in that realm. And finally, I just wanted to mention that we produced an explainer and privacy settings guide for internet browsing and social media use that's specifically designed for use by migrants and asylum seekers. And it was built on our existing research on social media monitoring, and it aims to basically protect migrants against invasive surveillance of their social media and online activity. If you're interested in reading more, as I said, I'll share some links, and they'll also be circulated after the event, along with slides and recording. And we also have a regular newsletter to which you can sign up with an option to sign up specifically for our migration updates. The link is on the slide here, and we'll share them as well afterwards. So with all these examples in mind, tonight we will learn from our speakers about how migrant communities are at particular risk of abuse of their privacy and data protection rights, which in turn threatens their other fundamental rights in their migration process. But we'll also learn how privacy and data protection law can be used to fight against these threats. So thank you everyone for being here, and I'll hand back to our chair, Louise, to kick off the roundtable.
Thanks very much. My intention is to do a little bit of an overview of what's to come. In early 2020, before the pandemic, I did a very short course on international law and artificial intelligence. And one of the people who spoke was an academic researching European border control. And he set out what I thought was a quite dystopian picture of what might happen in 2022 in the context of the Frontex regulations. And it turns out that something very similar is also happening in the UK. So I'm going to try and explain what that is. And I also have a slight concern that because of the way that it's been processed in the UK, it's passed much of the migration community lawyers, passed us by, because it's appeared in the context of customs and border control rather than migrants. So the background to this is that an awful lot of work has been done by bodies like Privacy International, other academics, and people like the UN Special Rapporteur on Race, who's written specific reports on race and technology, and very particularly on race and border technologies, looking at experimental uses of technology on migrants and how that will be used in the future to manage and control the Schengen borders and the frontiers of Europe, and also now the UK as well. It came to particular attention because of the funding of Frontex and the activities in the sea and on the frontiers in countries where perhaps there aren't as active civil society organisations, and so experimentation on disadvantaged groups is slightly easier. What has happened today, which is quite a landmark thing, is that the EU Parliament's refused to fully fund Frontex because of specific concerns about the lack of fundamental rights monitors and reporting and ensuring that human rights are not infringed by the border controls. The UK's border strategy is contained in a document called the 2025 Border Strategy. It was issued for consultation last year with a 5-week window. I haven't been able to find responses from any, there's no list of published responders as far as I can see. It was directed towards trade and industry to look at Brexit controls, customs and excise, and freedom of movement of goods. But within it, what you find is the story of Priasha. And I'm just going to try and share my screen, which shows us the expected journey of a person through a UK border in 2025. I would try and share my screen, except I've just lost it. Ollie, can I just ask you to check whether I'm sharing the right screen?
I don't think you're sharing a screen at the moment. Aha.
Does that show a box that says journey for a passenger?
Yes, it does.
Great, thank you. So this is the just taken from the middle of that border strategy. Priasha searches online to find out what she must do to enter the UK as a tourist based on the latest rules and regulations, and finds the guidance on permission to travel very clear. She understands the consequences of non-compliance. And anybody who's worked in migration for any period of time already knows that this is probably unlikely. She finds that she's eligible to apply for an e-visa. The application is straightforward and can be submitted online. Again, application forms very rarely straightforward. She applies for her digital e-visa online. Risk assessments are used to dynamically evaluate the application. And due to her previous compliance, she receives approval to travel rapidly and is provided an easy-to-use digital visa. So the first question would be, what are the risk assessments? How are they? What information are they based on, and how are they being used? The second thing that happens is that the biographic and biometric data collected by the carrier, not the government, but the carrier, and also provided by Priasha, is held in an interoperable format and is combined with other data sources by government for a joint law enforcement capability. And one of the intentions is to link both migration data with health data, for example. So what they mean by interoperable is something that will cross across multiple different platforms. And then Priasha crosses the border, enters the UK via an e-passport gate swiftly and securely, and the Border Force is able to use advanced risk analytics to identify that she is a low-risk traveller and allocates Border Force resources to higher risk interventions. During check-in, her departure data is automatically shared between the carrier and government systems for status compliance checks. So you can see at each stage of this journey, there are quite significant data gathering exercises and potential privacy infringement exercises going on. And this is the intention for the border that we will have in 2025, organised by an organisation that the Public Accounts Committee in March 2021 described as having a miserable record of exorbitantly expensive digital programmes that failed to deliver for the taxpayer or for border security due to a lack of effective leadership, management and oversight. So apart from the fact that this is quite a significant data gathering and combining and slightly unclear use of that data by the government, it may actually not happen, but if it does, then it poses quite serious risks both to the human rights and the privacy implications for individuals. And you can see an example of how that would harm someone if, for example, the data that was in the system was incorrect. And we've all had examples of clients whose data has been incorrect. We've had examples of clients who've used traffickers who've adopted somebody else's identity for them, and so they're linked. Their physical body is linked with the paper details of somebody else. And that can have huge implications if you're then put through a risk assessment to dynamically evaluate whether or not you should be stopped by the terrorism police at the other end of your journey, or alternatively, whether you should be allowed that visa to come and visit your husband or child or whoever it is. There has been a Freedom of Information Act request in respect of the development of these risk assessments and analysis. And the answer came back from the Home Office that they categorically refused to give any of the information, and that was upheld by the on appeal. So that's my dystopian future, which is not too far away. And just to add to that dystopian future, which for many of us actually will make our lives easier in terms of travel, but we're not the people that we're worried about. There's also work being done in the background by people like the Danish Migration Board on predicting migration flows. And at the moment, they, for example, estimate that they can identify between 1 and 3 years in advance where the next flow of internally displaced people will come from. And you can start to see how if you put that kind of information into a risk assessment by nationality or geographical location of the visa seeker, you may start getting refusals based on things like the price of goats. We know in some countries the price of goats goes up when people are preparing, so it drops when people are preparing to leave because more goats come on the market. And so if you're putting that kind of information into your visa risk assessment analysis, you could be refused your visa to see your dad and your brother because literally the price of goats has dropped. So that's another real concern. And in terms of the tools that we have to challenge this, a little bit of this is looking into the future, what's not quite what's happening now, but what might be happening in the future. So how to keep an eye on it. There's procurement law, there's human rights law, there's data protection law, there's equality and non-discrimination law. And in a pre-panel chat that we were having earlier today, I was talking about the AI and bias report that's just been released by the Centre for Governance of Data Ethics. And their conclusion is that the current Equalities Act is probably not sufficient to deal with the equalities impacts of algorithms and risk assessments, and may need stronger governance and have particular concerns in relation to policing. And I would think that many of those concerns in relation to policing, insofar as facial surveillance and safeguarding and risk assessing, are equally applicable to the type of technology that's going to be introduced at the border. So following on from that, I'm going to hand over firstly to Adam Straw QC from Doughty Street Chambers, who is going to talk about the intersection between data sharing between the various different public authorities in the context of domestic violence in particular. Adam practices in judicial review, human rights and civil claims against public authorities. He has experience of a wide range of fields, including discrimination, police, prisons, environmental challenges, social welfare, terrorism, children's rights, immigration and trafficking, and has acted in important recent public law challenges involving the right to life, deprivation of citizenship, open justice, data protection, pensions and welfare benefits. He's been involved in multiple challenges to data sharing between the police and the Home Office regarding victims of crime, which was a challenge brought by Privacy International in relation to bulk data sharing between the UK and international partners. A claim regarding disclosure of health data to an international corporation, and a challenge to a law requiring disclosure of criminal records about children for certain jobs. And on that note, Adam, I'm going to hand over to you. Thanks very much.
Thanks, Louise. I'm afraid that I don't have any slides to put up on screen, so you just have to look at the absolutely terrible pink colour that I've got in the background in the new house that I've just moved into. I'm sorry about that. My talk is about how to challenge data sharing between public authorities. There's a huge amount of this happening, and it's a real problem for migrants. For example, someone might want to access health, get an injection for COVID, send their children to school, or report being a victim of a serious crime, and they are at risk, as things stand, of their data being handed on to the Home Office and then being having immigration enforcement action taken against them. And the problem with that is that it means that these very vulnerable people often don't access these key public services because of the fear that enforcement action will then be taken against them. So what can be done to challenge that? I hope to use a case study today of a case I've been involved with for a while now, in order to try and illustrate some of the legal or other tools that you might use in order to challenge this sort of thing. And it's a case that was brought about by Liberty and Southall Black Sisters, which was a challenge to police data sharing, where when they come across a victim of crime, they share data with Home Office about the victim. Now, this started off with a super complaint brought by Liberty and Southall Black Sisters, This sounds like something from a Marvel comic, but actually it's established by sections 29A to 29C of the Police Reform Act 2002, under which you can make a super complaint about systemic policing problems, essentially. And SBS and Liberty got together some absolutely brilliant evidence to show that the sharing of data between the police and the Home Office, or the risk of it, deters people from reporting serious crime. And that really was crucial to the resolution of the super complaint, and also the course of the legal proceedings that I'll come on to. Now, when SBS and Liberty started off, there was no policy about what happened. Sharing between police and Home Office happened on a sort of ad hoc, random basis. Some people did it, some didn't. And so Liberty and SBS argued that there had to be a policy in order to ensure consistency as a public law principle in this context. There had to be a policy. And so a policy was produced, and it said that this was a police policy. It said that ordinarily the police will share any suspicion that a victim or witness of crime is of uncertain or unsettled immigration status. They will share that with the Home Office. And that was what Liberty then went on to try and challenge. There were two other aspects, though, of the policy which were important. The first of them was that it said that the primary purpose of police in this situation was to protect the victim. And it also said that the police themselves would take no enforcement action. They would just hand on the details to the Home Office to leave it to them. So we tried to challenge the policy. And the judicial review grounds that we relied on included the following. First of all, there was one based on Articles 2 and 3 of the European Convention. And those articles include positive obligations to put in place an administrative framework, so systems, policy, and so on, which provides practical and effective protection against serious crime. That's a broad systemic obligation. Now, there's some really useful case law about domestic violence in the context of Articles 2 and 3, which indicates that victims of domestic violence should be given special protection. And there's a case, well, there's a number of cases. One example is a case called Balsan and Romania from 2017, which said that a victim of domestic violence must have a system in place by which they can complain about being a victim of it and seek the authorities' protection. And so we argued under ground one that the evidence that victims would be deterred from reporting crime, so they wouldn't report crime because of the concern that they would be handed on to the Home Office, meant that the administrative framework didn't provide practical and effective protection against crime, because for some individuals, they didn't have any protection at all. They wouldn't report crime. So that was ground one. Ground two was Article 8. And under Article 8, the first question is there an interference? And we argued that the sharing of data between the police and the Home Office did interfere with Article 8. Now, that's quite a difficult question, but one of the cases we relied on was a case called Christian Institute, which you might find helpful more broadly in this context. Christian Institute against the Lord Advocate was a Supreme Court case from 2016, in which concerned a Scottish system where data about children was shared between public authorities in order for the purpose of safeguarding. And the Supreme Court decided that that system was incompatible. It interfered with Article 8, and it was also incompatible with Article 8. And the primary reason for that was that neither the children nor the parents were asked for their consent before the data was shared. And I'll come back to that in a moment. That might be quite a useful one in this context. So the first question, was there interference? We argued yes. And then the second question, which is normally the more difficult one, was the interference justified? Now, I'm sure you know there's a huge amount of case law about the question of justification, which indicates that a whole range of factors should be considered and weighed into the balance. And I won't go into the detail. I'll just mention three of the factors that we relied on in this case as arguing that it wasn't justified. So the first one is pretty obvious. It was that it caused serious harm. So it prevented victims of really serious crime, rape, threats to kill, from having any protection from the police. That's sort of, when looking at the balancing exercise for justification, that's a pretty weighty consideration. Second point, the sharing of data was inconsistent with the primary purpose of policy. And you remember the primary purpose was the police should be protecting the victim, and sharing data was inconsistent with that because it meant that a number of victims would have no protection at all because they wouldn't come forward. And there's some quite useful cases that say it's important to focus on the primary purpose of whatever scheme you're challenging and consider whether it's consistent with that. The third factor was looking at another purpose that was put forward by the Home Office to try and justify this, which was that the data sharing was justified for the purpose of immigration enforcement. And we argued that it did little or nothing to achieve that for two reasons. Firstly, the police themselves weren't going to take any steps to pursue immigration enforcement, and so sharing wasn't necessary to enable them to do it. But secondly, there was no evidence that data sharing in these sort of cases with the Home Office actually led the Home Office to take any enforcement action against particular individuals. And there's some useful case law which indicates that a public authority may be required to put forward evidence to show that a justification that they put forward is actually affected in a particular case. So to take one example, the Aguilar-Quila case in the Supreme Court in 2012, which was in which the Supreme Court decided that a rule which said spousal visas were only available to couples where both individuals were aged 21 or over when they were married. The Supreme Court said that that rule was incompatible with Article 8. And one of their main reasons for doing that was that one of the justifications put forward by the Secretary of State was that, well, this deters forced marriage. And the Supreme Court said, well, you haven't provided us with any information, with any evidence to prove that it does in fact deter forced marriage. And so we reject that as a justification. So that was another reason why we argued that this measure wasn't justified. The third ground of the judicial review was Article 14, so it's discrimination. And there were two aspects to this. One of them was that the sharing of data was direct discrimination on the ground of immigration status. So if you have unsettled immigration status, your data is shared. If you have settled immigration status, it's not. That's a difference in treatment on the ground of immigration status. And one of the advantages of Article 14 over the Equality Act is that a much broader range of statuses are protected. So under the Equality Act, you only have the limited list of 6 or 7 protected statuses, the classic ones of sex, race, and so on. Under Article 14, there's an ever-growing list of statuses which you're not allowed to discriminate against, one of which is immigration status. Now, that's an advantage of Article 14. A disadvantage is that discrimination is justifiable. Direct discrimination is justifiable under Article 14, whereas in most cases under the Equality Act, it isn't. The second ground of discrimination which we put forward was a thlimenos argument. What is that? A thlimenos argument is that if a public authority fails to make an exception to a policy or a rule for a group which is significantly different, then that itself may be unlawful discrimination. And we argued that there was a failure to make exceptions for particular groups here, especially for victims of domestic violence, and that those groups should not have their data shared because they're significantly different. There are a number of recent cases, both in Strasbourg and domestically, which indicate that thlimenos failures to make exceptions for victims of domestic violence were unlawful. Just to give one example, the case of OA against the Secretary of State for Education considered the rule where in order to qualify for a student loan, you have to have 3 years lawful residence. And the High Court decided that a failure to make an exception for victims of domestic violence to that rule was unlawful discrimination. And that was principally because of evidence that one form of domestic violence is preventing the victim from getting lawful residence, so from regularising their status. And the High Court decided, well, this was a good reason why an exception needed to be made. And that has obvious parallels in respect of police sharing of data, or indeed many other bodies sharing of data, health authorities, education authorities, where domestic violence is concerned. The last point about discrimination is justification, and the test for justification for discrimination under Article 14 is similar to under Article 8, except that instead of asking whether the measure itself was justified, you have to ask whether the discrimination, or in a Flemenos case, the failure to make an exception was justified. But otherwise, it's a similar test. I realise that I may be running out of time. Louise, is that about my time allocation?
In dereliction of my duties, I was listening too hard to think about the time. I think you could manage another 5 minutes.
Another 5 minutes, okay. Thanks very much. I'll crack on then. So the next issue that we had in the claim was a practical one. Who's the claimant going to be? An individual who is so scared about coming forward because of the possible risk of being deported that they won't even report being the victim of a serious crime to the police, probably isn't going to make a claim for judicial review. So who's the claimant going to be? We first made the claim on behalf of Southall Black Sisters as an NGO, but because we're relying on human rights arguments, you have to be a victim of the alleged breach of the convention. Now, there are very exceptional cases in which an NGO can claim to be a victim, which is essentially where you have enough evidence to show that the actual victims aren't going to make a claim. And in this case, that's the argument we made. We got evidence together to say that we've made loads of efforts to try and find individuals and couldn't find them. It proceeded on that basis, but eventually we actually found someone who was a potential victim. So she was at risk of the policy being applied. And she was willing to make the claim on the basis that she had full anonymity, not just in respect of the public, but that her identity would also not be referred to the defendant or the interested person, or the interested party. And pretty unusually, the High Court agreed that. And so her identity was withheld from both the police and the Home Secretary, which was pretty useful. So the claim proceeded. We got permission. The police withdrew the policy, issued a new policy, a new claim, withdrew the policy again, issued a new policy, new claim. Further justifications were put forward. They included, for example, that we're now sharing the data for the reason of safeguarding. So we're safeguarding the victim, and that's one of the reasons we're sharing this and why this is lawful. So we had to tackle the new justifications that have been put forward. I'll just deal with one of the attempts that we made to try and tackle those. So in terms of safeguarding, we argued that you can only, the police can only share data for the purpose of safeguarding if they have consent from the victim to do so. And we based that in part on the Christian Institute case, so in part on Article 8, and then in part on Section 35 of the Data Protection Act 2018, which indicates that, subject to certain exceptions, if you're sharing data for something like safeguarding, in other words, not for one of the law enforcement purposes, then you have to have consent to do so. The claim proceeded, and the claimant, in some ways, luckily for her, but in some ways, unfortunately, had a change of status, which meant we had to abandon the claim. So I'm afraid that the end of this story is that all of these issues weren't resolved by the court, and that there may be scope for a further claim to pursue these issues in future. But further developments happened after the claim came to an end. So the super complaint finally resulted in a report by the super complaint body, and that recommended that police forces immediately stop sharing data with the Home Office in cases of domestic violence. Some forces have stopped, some forces haven't, and there's a query whether a claim can be made against the forces that haven't, in part on public law grounds, that they're not permitted to depart from a recommendation from these bodies, at least unless they have a sufficiently cogent justification. Another development, the Domestic Abuse Act 2021, contains provisions regarding exactly this issue. So sections 81 and 82 require a review by the Home Secretary, a report in December 2021, and potentially a new code of practice on data sharing between the police and the Home Office. So watch this space. There may be scope for a further challenge to that. That was all I was going to say about sharing between the police and Home Office. The only other minor point that, just before I finish, I hope it helps to add, is another thought about a potential route to challenge sharing between public authorities of data. The GDPR Article 5(1)(b) and Recital 50 indicate that data which is processed for one purpose shouldn't then be processed for another purpose which is incompatible with the first purpose. And the practical way that that might help is if the NHS, for example, is sharing data with the Home Office for the purpose of enforcing its charging policy, which is lawful. If the Home Office then goes on to use that for immigration enforcement, you might argue that that's an incompatible purpose and so is unlawful under the provisions of the GDPR I've just mentioned. And that might have wider use in the education and other contexts. And that's all I was hoping to say.
Thanks very much, Adam, and I'm sure there will be lots of questions at the end for you in relation to that progress towards getting rights for migrant women who, in particular, who experience domestic violence and others. Next, we have Daniel Carey, who's a partner at Dighton Pearce Glynn. He's an experienced solicitor specialising in human rights, public law and data protection, with a particular interest in data protection under the EU GDPR, or now UK GDPR, e-privacy directive and public access to information under the Freedom of Information Act. His cases often focus on the crossover between data protection and human rights law, and has brought successful public law challenges and civil claims in areas as diverse as the unlawful sharing of asylum seekers' data and confidential information with persecuting authorities in the country of origin. That's something that we've recently seen as a mistake by the UK authorities in Afghanistan. The mishandling of information under the UK's Prevent guidance, data breaches by public inquiries, inconsistent responses to subject access requests by public authorities, advising a member of parliament on government data practices, and also successful legal challenges to unlawful state surveillance and data retention legislation, access to information regarding the UK's use of armed drones, and the list goes on and on. Dan, suffice to say, he knows more about data protection than pretty much anybody else I know. So on that note, Dan is going to talk to you about data extraction from mobile phones. Thanks, Dan.
Thanks, Louise. That's definitely not true, but I'll take it. I'm just going to try to share my screen, so bear with me, please. Okay. Hopefully you can see the slides, is that right? Is there there we go. Can everybody see the slides okay? Maybe a thumbs up.
Yes, you can.
Thank you. Okay, so I'm going to just talk through a case study, which is about an ongoing case which we're dealing with at the moment. I suppose at a more micro level than some of the kind of international departmental data sharing issues that we've talked about so far, and this is more of a challenge to a particular domestic Home Office practice which has emerged over the last couple of years, and that is the sharing, the seizure of migrants' mobile phones when they arrive in the UK, and what is done with those phones after they've been seized. So I'll just briefly focus on, firstly, the practice itself, what's actually been happening, the legal standards that are applicable, the litigation, the remedies at the end of that litigation, and then a brief nod to the wider context. I should say that because the litigation's continuing, I'm a bit limited in what I can say in some respects, just because disclosure isn't yet public. So what's actually happening? So the Home Office has developed a practice since kind of early to mid 2020 of seizing migrants' phones on arrival in the UK, with a particular focus on boat arrivals in Calais, which is the main crossing point, as I'm sure you all know. I have seen a few cases where phones have been seized after people have arrived in lorries and that sort of thing, but it's mainly focused on boat arrivals, and it's on covert or unsanctioned arrivals, whatever the current Home Office parlance is for people arriving here seeking asylum. And it's not just a matter of seizing the phones. PIN codes are also required to be given. Usually, as far as I'm aware, it's not sort of under threat of immediate arrest, but it's made plain to people that they have to hand over their PIN codes, and I'm not aware of anybody ever refusing. And then, quite remarkably, and this is what really brought it to the attention of a lot of migrant support organisations, the phones were just being kept by the Home Office, not for a few days or weeks, but many months, often periods in excess of 6 months. I've seen periods up to a year, and there's still a lot of people who haven't got their phones back yet. And also, when people's phones are taken, they're not really given a clear legal warning. Certainly in many cases that I've seen, the information that they're given is very limited. They're given an email address which they can email to try to ask what's happened to their phone. I think the practice has improved lately, but for pretty much all of last year and the first part of this year, nobody was answering those emails, or very rarely indeed. The photo there at the top, that's at Tughaven in Dover, which is the Border Force base where boats are taken to, and where the vast majority of these seizures are taking place. So, sort of in summary, there's the seizure aspect to this practice. There's then the retention aspect of keeping the phones for a long period, and then there's a kind of blanket nature of the policy and practice aspect. Our clients reports that basically everybody who was in the boat with them, they all had their phones seized, and there was a HM Chief Inspector of Prisons report last year which bore that out and observed that basically everybody was having their phones taken. I think the practice may now have evolved to be less blanket, but certainly for a good year and a bit, that was how it was happening. Just carrying on then with the practice. So what happens once the phones have been taken? Here we're in less certain territory, but we believe that data is then analysed on the phones and presumably extracted into some form of analysis software. One of our clients' phones we gave to an expert, and they examined it and found data images taken from after the phone had been taken from our client, which showed that the Facebook application on the phone had been reviewed. So it seems that cloud-based data is likely to be affected. And a couple of final points about the practice. The policy framework is largely unpublished. I mean, how people learned about this was migrants complaining to support organisations like Care for Calais and Jesuit Refugee Service and others that, where's our phones gone? But there wasn't any published policy, any substantial published policy at all. And of course, there are concerns about subsequent use of the data, whether it's police use, intelligence services use, or entries made on the police national database. We don't really know. And probably more concerning to our clients is, what will the Home Office do with this data? Are they going to sort of use it to rebut our asylum claims without us having a sort of proper right, to address what information has been taken and it is being used. So of course this has serious impacts in the short to medium term. When people don't have their phones, in many cases they've lost contacts with family and friends, and they've just come through an extremely traumatic experience, and that's can be very distressing. They may have asylum evidence stored on their phones which they can't access, and once they've gone through the system in the UK and are in accommodation, or more lately in asylum camps, their access to legal assistance is impeded if they don't have a phone, because as you all know, the migrant support system is quite a sort of peripatetic life for certainly the initial period until you're in dispersal accommodation, and a mobile's critical really to access support and establish social networks, and that's all rendered much more difficult for the people affected. In terms of the numbers, many hundreds I have estimated there. I don't think we have a confirmed figure on Foia, but I'm sure more will emerge in due course. So what are the applicable legal standards? Well, the power that the Home Office is relying on is Section 48 Immigration Act 2016, which is a power to seize and retain property from a premises when an officer has reasonable grounds for believing that an immigration offence has been committed. I mean, our initial response to this, well, there's no offence at all, but their justification is that the spectre of people trafficking means that there's a suspected offence in relation to basically anybody entering the UK via an unauthorised means. So they're justified in seizing the property under this section, and the Home Office claim that they can seize the items because they've detained and arrested and searched someone under Schedule 2 of the 1971 Immigration Act. But there are limitations on these powers. In particular, Section 48 it's supposed to be a power to seize from premises during a search of premises, not a power to seize from persons. And as you'll see when I come to the legal challenge, that's quite important. And there are other limitations built into the statute. So reasonable grounds are required to suspect an offence. The Home Office should be able to demonstrate that it was necessary to seize the item. And then there's protections also for the return of electronic items and the provision of copies of what's stored on electronic items. And the Home Office haven't been facilitating those rights of access. So the grounds of challenge in the case which we currently have ongoing, the first ground is that the Home Office practices ultra vires Section 48, which they're relying on, because they're breaching those conditions which I've just outlined. But we also make you might say, a more ambitious argument, but we also say that the power of seizure itself in Section 48 is one to seize from premises and not persons. And by using Section 48, which is broader in scope, the Home Office is circumventing the actual power for seizure from persons, which is in the old 1971 Act, the Schedule 2, which the Home Office are otherwise relying on for the powers of arrest and search. And they should really be using the seizure power in that schedule, which is much more limited and is just limited to seizing documents establishing identity or travel. So we argue that by trying to straining Section 48 to use it in this context, they're trying to sort of hammer a square peg into a round hole, and they should actually only be limited to the more limited power of seizure in Schedule 2 of the 1971 Act. In relation to requiring PIN numbers, that's a kind of separate argument, but we also argue that requiring those PIN numbers is circumventing another statutory power, which is in the Regulation of Investigatory Powers Act 2000, which is the power for requiring the provision of PIN numbers, and using Section 48 of the Immigration Act to require PIN numbers just isn't good enough. There is a sort of broad power, which I put in the PowerPoint there, in Section 48(4) of the Immigration Act, but it's not talking about PIN numbers. It's not specific enough for such a serious incursion into private information. So we say that there's no that Section 48 isn't adequate to require the provision of PINs, and we also say that it's unlawfully blanket in the way that the Home Office are applying this power, which takes it outside the scope of Section 48. And as you might expect, and Adam's already talked about human rights and to a degree data protection arguments, so I won't go into those, but we're also making those arguments in challenging this Home Office practice as well. And in terms of the litigation, so we at DPG, we were helping some migrant support organisations with sending PAPs, pre-action letters, to the Home Office to try to get people's phones back for them. And in many cases that worked, albeit after the Home Office took a couple of months to sort of wake up to the fact that wherever these phones were, and you got the impression they were in some cupboard in Dover, that they needed to like actually have an organised system for sending them back. But once they had sort of got into gear, then they did start sending phones back, but not in every case. So for 2 clients whose phones weren't returned, we issued judicial review proceedings, raising those grounds of challenge and seeking return of the phones. And there is another claim brought by clients of Matthew Gold and co-solicitors, similar arguments, albeit different sort of temporal period. And that claim also is issued, that was issued before our case. So our case is currently stayed behind them, but both sets of solicitors agree that really for the court to review what has gone on, for example, the PIN number issue and what was happening in sort of early mid 2020, it's sensible for it to hear both sets of cases. So that's what we're both arguing for. And it's likely the final hearing will be in January 2022. And remedies, nothing too surprising here, but declaratory relief that all steps in the chain of this Home Office practice have been unlawful: seizure, extraction and analysis of data, and the retention of the phones and the data that's on the phones. And also more sort of subject-specific remedies. For example, under Section 167 of the Data Protection Act, you can apply to court to halt unlawful processing. So to the extent that the Home Office is still retaining any of our clients' data, we want that to cease, and we want assurances that it won't be processed, for example, in relation to their asylum claims. And finally, just the wider context. That's a picture of whack-a-mole there, which for anyone who's involved in litigation against the Home Office, it's a sort of visual manifestation of what it feels like sometimes. Obviously, in any legal challenge, you've got to have regard to the broader context, because it may make the challenge more difficult or more or less impactful. And of course, there's always the risk these days that bringing these challenges sort of plays into the Home Office's hands a bit by helping them publicise these draconian powers, and plays into this sort of culture wars narrative, which is sort of playing out. And so one has to try and avoid that and just keep focused on the client's cases. But there's the immigration exemption in the Data Protection Act, of course, which the Court of Appeal declared to be unlawful, but as far as I know, that's still playing out. And then I've seen, thanks to PIs publicising this, but there are more specific phone extraction powers in the police crime, sentencing and courts bill, which perhaps puts on the statutory footing the sorts of practices which we're challenging in this case, which might give a clue as to how confident the Home Office are that what they've been doing actually was adequately based in statutory powers to date. But there's another power in that bill for the use of extraction powers by immigration officers. Well, I believe it's limited to where migrants consent, which also gives a clue. If they think they've got to legislate for extraction by consent, it suggests that to date they're unlikely to have adequate powers to extract without consent, but we shall see. So that's all I wanted to cover, but I'm very happy to answer questions now or at the end. Thanks.
Thanks, Dan. I think we're going to leave all the questions to the end, and I've noticed that there are a couple of them in the Q&A box, and I'll come to ask those after Ollie's talk, given his talk. So Oliver Percy is a practitioner at Garden Court Chambers, who is a rising star of the junior bar. He came to Garden Court from PLP, the Public Law Project, and specialises broadly in public law with a particular specialism in disability and migrant rights. He has particular expertise in judicial review claims raising discrimination, education, EU citizens' rights and retained EU law issues. He's worked on the EU settlement scheme and with the EU SS support hub, providing second-tier advice to law centres and vulnerable citizens. He worked on the Brexit litigation, Miller and Cherry v Prime Minister, and looked at the importance of parliamentary scrutiny of Brexit-related statutory instruments. Ollie's going to talk about Freedom of Information Act requests and migrant rights, what they can do, not do, and whether they're worth making at all. Thanks, Ollie.
2 years after a pandemic almost, and I still don't know when to unmute. Thank you very much. So I am going to give a whistle-stop tour through the relevant provisions of the Freedom of Information Act, as they might relate to someone that's trying to make Freedom of Information Act requests to get information primarily from the Home Office, but maybe from other public authorities, in order to advance migrants' rights. I've got 12 minutes, I think, so it's not going to be the most comprehensive tour in the world, but I hope to go through the key points and obvious blocking tactics by public authorities, how to maybe overcome them, and how to celebrate the wins when you get them. So that's my first slide. Right, nuts and bolts of Foia. You've got to make a valid request, and it sounds like an extremely basic point, and it is, but if you get it wrong, it can cause problems. So your request has to be in writing, and you have to have the applicant's name, or you can make it on behalf of an organisation. And for NGOs making requests, this is really quite an important point, because staff change, and Foia requests and the challenging process, the process of challenging thereafter, can drag on for a long period of time. So make sure that you put on behalf of whatever NGO you work at, and then someone else in the organisation can pick up the challenge later on. It's not attached to the individual. It has requests for information held by a public authority. Note the schedule of public authorities in Foia, it's not all of them. And you need to put in your address for correspondence. The What Do They Know website is quite a useful tool for making them. So grounds for refusal. Here are two obvious ones where you get knocked back quickly and how to address them. So cost. Generally, it's 600 quid for a central government department, 450 quid for local authorities, etc., other public authorities. Be careful how you frame your request. So it's a very obvious blocking tactic for the Home Office or whoever to come back and say, it would be too expensive for us to do this, unfortunately, bye-bye. And they don't need to go to a public interest justification if they do that. What you can do to get around this, or at least limit the risk of it, is to say, please prioritize year one, the most important year that I want information for. And when your budget runs out, stop. So coming up with tricks so that you get at least some of the information before the cost cap hits you is a way of maximizing your prospects of success. Be careful and look on what do they know to see what other requests have been made. The public authority is within its rights to aggregate requests by you. So you're not being especially clever if you put lots of separate requests in, or aggregate requests that others have made to reach this cost threshold. So if on what do they know or other websites that have displays of Foia requests, there are similar requests that have been made, the public authority can reasonably conclude that you're acting in concert with them and aggregate the cost limit between you. The vexatious request I'm not going to go into in any detail because of the interest of time, and I've never actually seen it being used. One final point on cost. They can rely on their own terrible record keeping. So if it would take them a long time to navigate their own poor file management, that's perfectly permissible, unfortunately. So what are the qualified exemptions? So these are exemptions that are subject to a public interest balancing exercise. And the 5 key ones that I've come across in the context of migrants' rights are future publication, risk to international relations, law enforcement, which specifically includes immigration control, formulation of government policy, and personal information. I'm not going to go into any detail about personal information. Quite often it's the names of junior officials. Generally you can get the senior officials' names, but not more junior. And why would you want the more junior person's name? So be careful what you ask for in relation to personal information. Future publication is a common one which I have seen. So the key test is set up questions that the public authority really needs to answer when deciding whether to release information and whether this exemption is engaged, is at the time of the request, did the public authority hold the disputed information with a view to its publication at some future date? And note wording of that. At the time of the request, did they have that intention? Not when they received, not subsequent to receiving the request. If so, is it reasonable? Well, there are various factors that can go to reasonableness. For example, the importance of transparency of decision-making, the importance, the long wait time that they're giving, that they've already committed to publishing in the short term. All of these might be factors that go to reasonableness. It's not an exhaustive list of what's reasonable, it's the usual reasonableness standard. Formulation of government policy. So this is a relatively loose test, but it seems to be invoked more often than it should be, even under a loose interpretation. And I've quite often seen it in relation to implementation of government policy. That is not formulation and cannot properly be relied upon by a public authority when trying to stop you from getting information that they don't want you to have. But relates to is a broad test. It doesn't have to just be the actual formulation. It's a looser connection to the formulation test. So how do you go about challenging refusals? Well, there's the internal review, which is an admin review. Another caseworker in the public authority marks their colleagues' homework. Minimal success in my experience. This isn't even a requirement, but it is recommended, and the statutory code of practice, I think, says about 20 days for a response to this. But you frequently see long delays by public authorities in actually responding to Foia requests. And that's one of the key pitfalls of the Foia process, is it's marked by extensive delay and difficulties in making public authorities actually engage and meaningfully, substantively respond. Then the next step is a complaint to the ICO, and the ICO does have powers and is prepared to use them. But there's a right of appeal which doesn't have a permission threshold, which a public authority, when ordered to disclose by the ICO, can exercise, which again slows down actually getting access to the information that you're seeking. So one example that I wanted to speak to in the time that I have is some brilliant work that JCWI did, and which I worked with them a little on when I was at Public Law Project, which was trying to extract the policy equality statement for the EU settlement scheme from the Home Office. Now, for those of you not familiar with the EU settlement scheme, it's the scheme by which EU citizens apply to register to stay in the UK after Brexit. And it's a sort of unprecedented new immigration application process. And lots of people working in the migrants' rights field had very serious concerns about the equalities implications of devising this new scheme from scratch. Everything from automated decision-making in determining how long someone had continuous residence to the approach to victims of domestic violence, to what would the approach be for EEA nationals versus non-EEA nationals, etc. So I'm not going to go through the timeline in great detail, mostly because I don't have much time to speak to this. But as you'll see, it was a very protracted process. The policy equality statement had been long promised by the immigration minister, Caroline Noakes, at the time, in 11th of June. In response to parliamentary questions, he frequently said, "Oh, it's being published shortly. It's going to be placed in the library shortly," which is the House of Commons library, not her own personal one. And so in August 2019, JCWI, or Chai Patel on behalf of JCWI, put in this Freedom of Information Act request, essentially asking for the policy equality statement. And as you'll see from the timeline that I put on the screen, there was a lot of back and forth, internal review, then ICO complaint, ICO orders the Home Office to disclose, and then the Home Office challenges further. So if you look at point 8 on my slide, and it invokes further exceptions, which are, in addition to we're going to publish it soon, it relied on international relations and law enforcement, specifically the immigration control provision. Fast forward to September this year, so earlier this month, and it's finally disclosed the version of the policy equality statement that got published in November. So a version was published in November 2020, but the May 2019 version was published in earlier this month. It took over 2 years Foia process to get hold of the policy equality statement for the EU settlement scheme, or at least the May 2019 version in place when the Freedom of Information Act request was made. I think there's a really interesting point in relation to this, which I don't have a huge amount of time to go into, but actually part of the PES, the annex, was not published, and that related to a sort of a risk assessment that was being undertaken in relation to non-EEA countries, and it essentially had a list of countries that they considered to be at high risk of potentially committing immigration fraud, and they didn't want to publish that list of countries because it might be harmful to international relations if we had named them publicly, and it would also undermine immigration enforcement because people in those countries would understand, and this is the reasoning put forward by the Home Office and accepted by the first tier tribunal, is that knowing that you're on this list of countries at high risk would somehow help you to bypass it, which seems quite extraordinary reasoning to me. But anyway, in the limited time that I have left, I wanted to do time for questions. I wanted to distill down some key tips for making Freedom of Information Act requests and placing them in a wider strategy to obtain information that might help you to gain useful information for judicial review, campaigning, whatever it might be in the migrant right context. So first, make use of the Foia Code of Practice. It has helpful guidance, particularly, for example, in relation to the advice and assistance duty, which I mentioned later, about what the public authorities should be doing to help you to frame your request so you can get that information that you want. Remember that FOIA relates to information, not documents, and therefore the exemptions have to relate to specific parts of information, not blanket to documents as a whole. So it's not we either disclose this document or we don't. It has to relate to the specific information contained within. Preempt the exemptions that are going to be relied upon in a public authority's response. So, as I mentioned earlier, preempt cost and put in a formulation of wording that makes sure that you get at least something out of it. So they prioritize how they spend their budget, but also set out very clearly how you think the public interest test applies, preempt what you think will be their arguments against publication and debunk them. Because the worst possible thing is having a back and forth and delay, which means that you don't get what you want. And quite often these are time-sensitive requests. For example, the EU settlement scheme has now closed since and now we have the May 2019 version of the Public Policy Equality Statement. Make the most of the advice and assistance duty. I've mentioned that. Look for wins in refusals. So whilst they might invoke an exemption in the Freedom of Information Act, there can be concessions hidden within that exemption. So, for example, in the formulation of public government policy argument, I've seen it conceded that they actually haven't got a policy because they're trying to develop one. Finding out that information is actually useful information because the absence of a policy can be unlawful. Look for other FOIA requests on what do they know. Quite often someone will have made a FOIA request on the exact topic you're looking for, and therefore you can bypass some of the delay in getting that information. So there's a whole bank of them, of previous FOIA requests on whatdottheyknow.com, and I'd well recommend using it. And how else can I get this information? Well, there are other tools apart from FOIA. That might be subject access requests, that might be parliamentary questions, that might be writing to the Home Office outside the FOIA process. Think creatively, or it could be a pre-action letter engaging the duty of candour and cooperation. There are other ways, other tools in your armoury to get information out, and FOIA is just one of them. And sometimes you can piece together information that you can secure through different avenues to get a more complete picture. So that's the end of my presentation. Thank you very much.
Thanks, Ollie. In terms of what happens next, an email with links to resources and slides will be sent out tomorrow, and then that will be followed up next week. And I'm saying that because there are various people who've indicated that they need to leave at around this point in time, so at least you'll know that that's what happens next. And then we've got a couple of questions already in the chat, and if anybody else has got some questions, if you put them in the chat, I'll try and collate them and ask them to the panelists. Adam, there are two questions that relate to domestic violence and data sharing more generally. The first one is that you said that Liberty put together very compelling evidence to support the super complaint. Could you say a little bit more about the aspect, the evidence gathering? Why was it particularly strong, and what sort of evidence would people be looking for in these kinds of cases?
Sure. So I put a link in the chat to the actual super complaint itself, and that's it's a long document. The evidence is contained throughout the document, but in particular from paragraph 75 onwards. Liberty and SBS also obtained a range of other evidence as the proceedings carried on. The super complaint was issued in 2018, and it's still been going on. This has all been going on since then. Just to summarise it, some of the evidence was specific case studies. I think all of them, I think, were anonymized. So individuals who said to Liberty or to SPS, I was the victim of a serious crime. So they were crimes of domestic violence, very serious issues, rape, ongoing campaigns of threats to kill and violence. I have uncertain immigration status, and one of the reasons for that may be that the perpetrator has prevented me from regularising status, has kept my documents, has threatened that they will undermine the claim if I make it. And because of my fear of being deported to wherever it is, and an explanation of what the consequences of being deported may be, I am not going to go forward to the police to get protection from these terrible crimes. And so there were a series of case studies like that directly from individuals. There were then a number of other sort of interviews with NGOs and specialists, which were sort of hearsay. So people who weren't actually recounting the specific case studies, but saying, yes, I have talked to 20 people, or I've talked to a large number of people who are in this situation and aren't coming forward. And then there were also sort of expert opinions of people saying, okay, I'm not talking about specific cases here, but it's obvious that this happens, and very large numbers of people come to our organisation and complain about this. So that's sort of a summary of the evidence.
And before I move on to the second question about the National Police Chief Council's guidance, I think that brings up a question that I'd like to ask to all of the panellists, which is about this idea of using data for one purpose for another purpose that Dan was talking about in his presentation, and about whether or not we're seeing this cutting across different sectors, and whether there is anything in particular other than looking at the angle of challenge through the GDPR that we might be able to do about it. And I'm thinking in terms of necessity and proportionality. But perhaps, Dan, you want to come in on that, if you understand the question.
In terms of if I know of other areas of problematic data sharing, there's none that are springing to mind, but it's true that the overall trend, as you might expect, is a kind of increasing aggregation and cross-pollination of data. And the obvious way to challenge it is where it lacks an adequate policy framework and isn't in accordance with the law. But I suppose there have been challenges around healthcare information and Home Office, sharing that with the Home Office. We've got the same thing happening here with the police, and I guess if you were looking around at other areas of government, you'd be looking at education and the other sort of main functions of state, and I'm sure there's plans afoot, if not already well in train. So there's lots for people to use things like Foia and other means to investigate, for sure.
Ollie, do you want to add anything to that?
Yeah, I think it's worth thinking about, for EU citizens in particular, the withdrawal agreement as a source of protection for rights going forward. The citizens' rights provisions in particular, because Article 4 of the withdrawal agreement helpfully sort of acts as a gateway for EU law general principles, where they, if there's a reference to union provisions in the citizens' rights provisions, they have to be interpreted in light of EU law, which EU law as it evolves. So it's not just retained EU law as we might be using in some domestic litigation here, but you can use evolving EU law more readily, and parts of the withdrawal agreements and rights provisions have direct effect. So I think there's potential to use those provisions creatively, maybe. I haven't given it that much thought in the data protection context. Yeah, potentially interesting, and particularly with digital status, with the EU settlement scheme being a sort of pioneer for that. I think, yeah, we'll see quite a lot of I think withdrawal agreement is going to be an interesting ripe area for data protection, privacy right protection going forward.
Thanks. And Adam, do you want to add anything to that?
I suppose only on the question of incompatibility of further processing. If you've got a case, for example, in the health context, which we were talking about earlier, the data is collected for health reasons and then passed on to the Home Office in order to try and enforce the charging policy, which unfortunately is a lawful policy. And we know already from the case of W in 2016 from the Court of Appeal that it's lawful to pass on the data for that very specific purpose, enforcement of the charging policy. But what about, can the Home Office then use that for immigration enforcement purposes? And the question as to whether the two are incompatible is a slightly tricky one. As I said, recital 50 has got a list of factors that you can take into account, which are sort of common sense things. What are the consequences of the issue? What are the consequences of the sharing and the further processing and so on? But the Court of Appeal decision in W might be useful in that respect because it indicates that the sharing of data is lawful only for this very narrow purpose of ensuring the charging policy is effective. And you might rely on that to say that therefore any broader use of that data is unlawful. But to explore that further, have a look at recital 50 and have a think about the factors that it identifies there.
Thanks very much. And the second question, which again is for Adam, is about the is from Una Boyd, CAJ. I noticed that the National Police Chiefs Council guidance from 2020 on data sharing with the Home Office doesn't mention any of the recommendations coming out of the super complaint. Has this been raised? Police forces have been relying on this guidance when their data sharing practices have been queried. Have you any more information about that? So I noticed that in response to that, Lara Ten-Katen, who's one of the solicitors at Liberty who's dealing with this, responded to say that she would be happy to discuss this. I'm sorry, it's probably better if she does that because I know that some of the information we've received from the litigation isn't yet public, and so I'd be concerned about disclosing something that I shouldn't. So sorry to give I can't respond answer, but that's absolutely fine. If I could work out whether or not Lara can speak, I could perhaps give her the microphone, but I'm not sure I can do that on this setup. Apparently I can. Amy, I would like Lara Ten-Katen to have the mic. Obviously, if she's happy to take it, that's the other thing.
Hello.
Hello.
Hello. Okay, just to say very briefly, the super complaint actually came after the 2020 guidance. And very recently, together with SBS, we are having meetings with the Home Office because one of the recommendations is that they should consult frontline organizations in order to issue new guidance. And as part of that, it has become apparent that, in fact, we learned today that the NPCC has written to all the police forces to say that they do not agree with the main recommendation of the super complaint, which is that they shouldn't share the data of victims of crime temporarily until such a time as there is a new guidance in place. So it's bad news, really. And there is not much more to say about that. We have raised it with them. And of course, we have said that we think this is outrageous and that it diminishes the willingness of organizations to bring a super complaint in the future. So sorry, it's not helpful, but yes, it is known. We know that this is happening and we have been trying to raise it.
Thank you very much. We've got one comment in the question and answer box, which is aimed at Daniel. to suggest that given the precarious nature of asylum seekers' journeys to the UK, many relatives who can't be contacted by their asylum seekers who've arrived here, their family members, must be left with the impression that their relatives haven't survived. And maybe there's a case under the Human Rights Act, right to family life, and is that something that you've considered?
Thanks. Oh, I've got a weird echo. I'll try and ignore it. Yeah, I think you're absolutely right. I mean, certainly we've pleaded violation of Article 8 ECHR, although I suppose principally in the sort of traditional invasion of privacy context, but you're right, the right to private and family life should extend overseas. I don't think that raises a jurisdictional issue because the victim is within the jurisdiction. I think you're absolutely right, and it probably is helpful to refer to the wider corpus of refugee law in making those points. And factually, yes, I agree. I mean, people have found it much harder to contact relatives, and I don't have sort of direct evidence of what those relatives have felt, but I'm sure it's been a time of considerable uncertainty.
Thanks very much, and I'm mindful of the time with 1 minute to go until 6:30, and that everybody will probably want to get off. So I want to just say thank you very much to everybody for coming, to Privacy International for co-hosting with us, to Adam from Doughty Street Chambers, to Dan from Pierce Glynn, and to Ollie Percy from Garden Court Chambers. I think that summary gives us an idea of the current challenges and the likelihood that over the next few years they'll probably get worse. Hopefully for people who weren't aware of some of the issues that migrants are facing in relation to their data and the invasion of their privacy, that will help enlighten us and enable us to take the protection of migrants' rights forward. And I'd just like to finish with the recognition that most of the technology that's been developed over the last few years has got a clearly racially discriminatory impact. And our client groups are most likely, out of all of the groups, to be affected by the imposition of those forms of new technologies on them. And therefore, it's really important that we are alive to that when going about our daily practice as predominantly migration lawyers, but also privacy lawyers and professionals. So thank you very much to everybody for coming, and we'll send you the links through the email. Thanks very much.